Welcome to Notable Approvals. I'm attorney Amanda Shaffer. Before we get to our case today, just a reminder to like us and follow us on Facebook, Instagram, Twitter, so that you don't miss any more of our lives or anything else that we do that has lots of information and hopefully you'll find useful. So today's case is a little interesting. I was originally going to wait to do this case because this client was supposed to have his individual hearing or his merits hearing in removal proceedings in the first week of January. But unfortunately, his court date has now been postponed because of the coronavirus. And the legal issue involved that I wanted to talk about with his case is pretty complicated and it's fresh in my mind. So I thought I would go through it today. This client is a native and citizen of Mali. He first came to the US back in 2002 when he was 16 years old. He came with like a tour group. They were on vacation. And when he decided he didn't want to go back to Mali, the tour group operator said, well, you could stay here, but I need to take your passport from you and get it stamped, or they're not going to let me take more kids to the US. My client had no idea what, he was just a teenager. And this was the chaperone of their group who held onto his passport and wouldn't give it back. So my client stayed here, never left the country, and his passport went back to Mali. Then less than a year later, he called his mom and said, I want to enroll in school. I need my passport. So his mom went to the tour operator, got the passport, and then sent the passport with someone who was flying to New York, sent the passport with that person, and my client got back the passport. And in his passport, you see the entry stamp in 2002, then you see an entry stamp in Mali in 2003. But my client never actually left the US. And this used to be a common scheme that would take place where the reason why is that this tour operator, he wanted to bring more people here. And if they thought he was just bringing people to the US, not for vacation, but to stay here permanently, they wouldn't allow him to continue doing it. And so he paid someone off in Mali or knew someone to get the passport stamped. And in fact, it wasn't just my client in the tour group this happened to, it was the entire tour group. Or whoever stayed behind from the tour group, they all could not get their passports back from this person. So after that, he enrolled in school, married a U.S. citizen. She filed for him. It gets denied. It gets denied because they say, we believe that you left the U.S. in 2003 and illegally re-entered. And so because of that, he was placed into removal proceedings in 2008. He got divorced, he got remarried, his new U.S. citizen wife files for him, and that gets approved in 2011. And at the time, his previous lawyer filed a motion to terminate removal proceedings. And that was very common, especially then. Right now, that's not being allowed. There's debate if a judge can terminate in those circumstances. The judge was terminating in order to allow him to get his green card with USCIS instead of having to go through the court system. So they filed this motion to terminate. And what was interesting is eventually, when I'll get to what happened more recently, but I heard all the tapes from his previous hearing. And in the previous hearing, the judge said to the attorney, look, you haven't shown me any proof that he never left the US. And if you go back to USCIS and they deny it, you're just going to be back here. And the attorney said, okay. And that's why the judge terminated, and Department of Homeland Security didn't object. So in 2014, USCIS denies his adjustment of status application again. And instead of waiting for DHS to get around to putting him back in removal proceedings, obviously he wanted things moving along because you're not automatically back in removal proceedings if your case gets denied. His attorney filed a motion to reopen removal proceedings. And DHS filed a non-opposition. They didn't even just ignore it. They filed a piece of paper that said, we do not oppose reopening removal proceedings. So the judge granted it. And They scheduled him for a master calendar hearing. That's when we got retained as his attorney. And then at master, we were scheduled for an individual hearing in June of 2019. So June of 2019 comes around. We have witnesses that were with him on the trip. We have all this evidence, a witness that flew him from, I think, Ohio, people who took off work. We had all this evidence. We're all ready to go at his individual hearing. And we get there, and the attorney for the government goes to me, we want to file a motion to rescind. A motion to rescind what? A motion to rescind the judge's order reopening the case. The judge didn't have authority. I go, 5 years ago, you guys said that you agreed to reopening the case. What do you mean now you don't agree? You can't just change your mind. I could never say, oh, my client's case should be terminated, but now it shouldn't be terminated. Oh, phones are ringing here. Let me mute that. So I said I was listening to the tapes. That was the day I sat there with the attorney for the government and the judge and listened to the tapes. And it was a strange thing to do. I've never done that in the court. Normally, if you review tapes, it's, in the back room or something. And my client was sitting in the waiting room, had no idea what was going on. And I'm arguing with the other attorney saying, look, you can't change your position 5 years later. B, there's no grounds for what they're asking for now. And the judge was allowed to reopen the removal proceedings. And, it's a little too late for that. This should be denied simply because this is not fair. And of course, the judge gave them an opportunity to file the motion because that's what happens. The judge doesn't want to get appealed. So the judge gave until September to file a motion. September comes, September goes, no motion. November comes around and we get a new notice in the mail. So his individual hearing had been moved to March 2020. In November 2019, we get a notice saying he's been rescheduled for a master hearing, which is not the final hearing, the merits hearing, but a master hearing in February 2020. But we never got anything from the government. So we were like, this doesn't make any sense because nothing's changed in the case. So, and you can't get answers, unfortunately, until you go to court. So we go to court in February, and that day in court, the government attorney hands me their motion to rescind. I loudly object to the judge that this is untimely. You gave them a deadline of September. We are in February. This is not fair. This is not fair to my client. But the judge still considered it because the timing, the deadlines were kind of faux deadlines for something like that. There wasn't real statutory deadlines, and gave me a date in which to respond to, which I did. I put in a very strong opposition. My client's case was then moved to January of 2021, which, as I said earlier, now it is, we don't know the new date yet. But anyways, so the judge a couple weeks ago denied the motion to rescind. And the judge denied it for all the reasons that we stated in our brief. Basically, and it's confusing, but I'm going to go slow because I think this is important to understand. It's procedural, but especially for someone listening who's in court and doesn't understand how everything works, maybe this will help give a little insight. So, first of all, there's no such thing in this context as a motion to rescind. If you look at the regulations, it says there can be a motion to rescind in certain circumstances, and it lists all of them, not to rescind a previous reopen order. Essentially, what DHS was really asking for was a motion to reconsider. And when you ask them to reconsider, you have to say to the judge, either there's a factual error or a legal error or both. And that's why the decision should be reconsidered. The judge agreed that it should be, and actually called it a motion to reconsider. So the legal error that they were claiming was that the judge did not have the authority to reopen the removal proceedings. And the problem is that the judge did have jurisdiction. There was no legal error there. Once you get served with that notice to appear in immigration court, the judge has jurisdiction over your case. And jurisdiction stays there until there's either a final decision and you're no longer, well, actually, I shouldn't even say that. With a final decision, technically jurisdiction still can remain with the judge. unless there's an appeal to the BIA. There was no appeal to the BIA. Jurisdiction remained with the immigration judge. So the immigration judge has the authority to reopen or reconsider any decision he or she has made. And a motion to reopen is a decision. Therefore, the judge had jurisdiction to reopen the case. Then the other issue raised by DHS was that the judge did not have authority in the first place to terminate removal proceedings. Now, if you're watching this and you're an immigration lawyer and know what's been going on these past 4 years, or you follow any of this in depth in the news, you'll know that there's been a lot of talk about terminating proceedings and administrative closure and whatnot. That changed drastically between Obama and Trump. But what they were essentially arguing now is that, yeah, we agreed back then that the judge had the authority to terminate, but now we're saying the judge didn't. She should never have terminated. Oh, and I forgot one thing. The judge on this case was not the same judge back in 2011. The judge in 2014, whenever it was, that judge retired. So that's what the other reason we had to listen to the tapes. The judge wasn't there when this happened. She was actually an attorney for DHS at the time. So they said the judge did not have authority to terminate. So you go to the regulations. Well, in the regulations, it lists specific things that the judge has the authority to, or specific grounds on which the judge can terminate a case. And the judge, so they're saying she didn't have legal authority back then to terminate, but the judge has legal authority now to terminate. Well, the legal authority back then to terminate, we did deal with that argument, but it wasn't as important because the judge had jurisdiction to reopen. It kind of moots that the argument that she shouldn't have terminated in the first place. But the judge having authority to terminate now, we said, no, she does not have authority to terminate now because the regulations, again, it lists certain things. Like one of them is to apply for naturalization. One of them is if you've proven you're not removable, so you're in lawful immigration status. So none of those grounds that are listed in the regulation applied. So we said there's no authority here to reconsider and to terminate the proceedings, because effectively what would have happened if the judge agreed with the Department of Homeland Security is that my client's case would have been terminated. And he would have been stuck in this legal limbo where if he goes back to USCIS and applies for a green card again, they're going to once again say, we believe you left the US and illegally re-entered. That issue is going to be litigated before the immigration judge. And it's very different before the judge as it is with USCIS, because when you're before the judge, I'm the one asking the questions. We can present evidence. There's a neutral, there's the judge, not just an immigration officer. So it's a very different environment, and obviously it's a different person. So what would have happened then, in order for him to get back before the judge, is that Department of Homeland Security would have had to give him a new notice to appear in immigration court. And the Department of Homeland Security has unfettered discretion as to when and to whom they issue these notice to appear. So it's possible. I mean, you watching out there may know somebody who has been in this country illegally for 20 years, 30 years, has never been in immigration court. And you may know someone who's been here for 6 months and that got unlucky and got stopped on a bus and is now in immigration court. So they can do whatever they want. If someone's here illegally, they can put them in immigration court, or they can use their discretion and not put someone in immigration court. And that's where things get tricky. And the judge turned to the Department of Homeland Security attorney and said, so what is your grand plan here? Are you going to put him back in removal proceedings right away? I mean, are you not going to? You're going to let him stay here without status? If we lost at trial on the issue of whether he left or not, then he would have had a, sorry, I'm getting distracted because there's other things going on. He would have had an order of removal or an order of deportation, and the government could have literally deported him. So I believe that the government thought they were going to lose this issue, and that's why they were fighting tooth and nail. And their ultimate end goal was that they were going to leave my client in legal limbo, and that he would get frustrated eventually give up and leave the country. That was the only thing that made sense as to why they were doing what they were doing. Fortunately, the immigration judge did not agree with them, agreed with our argument. And literally, if you read my brief and you read the judge's decision, they're very similar. And that means I did a good job. And I want to read my conclusion in this case, because this case, if you can't tell, I'm passionate about this case. I'm passionate about all my cases. But this case, it really bothered me. And it bothered me because I felt that DHS was not acting in good faith. I thought they were messing around with the court system when making my client spend extra money, making my client go to court more, dragging out his misery and his family for zero reason. And so at the end of my brief, this is what I wrote. This court should deny the present motion to rescind because the immigration judge order reopening respondents' removal proceedings was a valid exercise of judicial authority, and DHS consented to the reopening. DHS is not given a carte blanche by the regulations or statutes to change positions at will. A grant of this request more than 5 years after this decision was consented to will not only be a waste of judicial resources, but it will set a dangerous precedent that allows DHS to change position on material issues at will, the effect of which will be felt far beyond the instant case. The uncertainty created by such a precedent is unjust and deprives the process of fundamental fairness. And you don't always use language that strong when you're writing these briefs, but I felt it was appropriate here. The judge didn't cite that part, but the judge got the gist and granted or denied their motion and agreed with us. So, things are not always fair in the immigration world, especially when it comes to immigration court. And this is not just the past 4 years, but ever since I began practicing and well before that. But if you have passionate and diligent, competent, experienced representation, like the attorneys at the Shapiro law firm, we are going to make sure that you're not deprived even the smallest bit, the scintilla of fairness. You deserve every part of due process that the law allows, and we're going to fight and make sure that you get that. This was a long one, but again, I think it's a very important case because no matter what, we should not allow our government to trample over our rights and really do whatever they want. We have to take a stand when these things happen. And this was actually not an easy motion to oppose because it was just it kind of came out of left field. There's not much case law on it, and it really wasn't grounded in law. So I'm thrilled for this client. I do think we're going to win on the other issue of whether he actually left the country or not. But unfortunately, we still have to wait for his next hearing, whenever that may be. The New York courts have not been open since last March. That was one of the last cases I was at before the court shut down. In person, I was there, obviously. But unlike some other courts in the U.S., the immigration courts in New York City have remained closed ever since. So hopefully they'll figure their stuff out, open soon, and then people like my client will get their cases rescheduled and can move on with their life. So if you need representation in removal proceedings or in any of your immigration matters, contact information's been scrolling across the screen. Contact us. It's holiday week for a lot of people, but I'm at the office, I'm working, I'm here for you. Give us a call, send us an email. Don't forget to like us, follow us on Facebook and Twitter and all of that stuff, and Instagram, so that you don't miss another live. That is all for today. We'll be back tomorrow for our final notable approval for 2020. Thank you for watching and have a great day.